Hello, and welcome to Crime and Court. My name is Heather, and this is yet another Delphi video. However, I am going to mush a bunch of motions and things into this one video, so you don't have to keep bombarding you with videos. So, trial is 2 weeks away, less than, and for the Delphi unalivings case. Can't say certain words on YouTube, so I don't know why I'm lagging now. This is great. What the flying farfignugan. I feel like I'm really lagging. Anyways, okay. I'll take a look at it before I post. So here we go. Please hit the like button before we dive in. I have a lot to get through, so let's just do it. All right, so the first thing that I'm going to read to you is an email from Judge Gull to all of the attorneys in the case. She says, "Good morning. I will answer." This was Sunday, April 28th. She emailed us to them. "Good morning. I will answer your questions as follows. The intent is that jury selection will take 3 days. Court will be in session in Allen County beginning at 8:30 a.m. and concluding when we conclude for the day. We have all been provided with the sub-panel lists broken into morning and afternoon sessions. I will forward to you under separate email the seating charts for courtroom 1 and the strike sheets we will be using for selection. The selected jurors will be sworn in upon selection and ordered to not speak or communicate with anyone about the case and to conduct no research on the case. They will further be ordered to return to the Allen County Courthouse on Thursday morning with their luggage and personal effects, which will be searched by law enforcement officers. Their luggage and personal effects. Which will be searched by law enforcement officers to ensure that they are bringing nothing electronic or illegal. Once that is complete, they will be transported to their hotels by staff. So these people are being sequestered. Oh, shit. All right, so the order I referenced above contemplates an invitation to the media to meet with me in the Carroll Circuit Courtroom Thursday afternoon so that they can take photographs of the empty courtroom and B-roll footage of the courtroom for their stories and broadcasts and to receive their press credentials. This case was set as a speedy trial at the request of the defendant for May 13th through the 31st, 2024. This is the length of the trial, not more or less. When the order was issued, not one attorney notified the court that the length of the trial was insufficient. In fact, it is consistent with a previously scheduled length in January 2024. I intend to start court every morning by 9 a.m. and recess for the day around 5 or 6 p.m. Court will be in session on Saturday perhaps for the entire day if necessary. Saturday. Going to Saturday sessions? Court will be in recess on Sunday to allow the jurors and the parties to rest. I guess because they're being sequestered, you want to get your most time out of it, but I don't know. Okay. I am unaware how many witnesses the prosecution intends to call, nor on how long their case will take to present. The defense is claiming it will take a couple of weeks to present its case. I am unsure what exactly the defense intends to present. I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators and the charged crimes, those allegations are unsupported and will be inadmissible. Frank's memo, anyone? Please be prepared to present your cases timely. Have your witnesses available quickly and promptly. I look with disfavor on counsel attempting to manipulate the presentation of evidence by timing witnesses poorly. That conduct will not be permitted. The jurors' time is valuable, especially since they are sequestered and away from their homes, families, and jobs. Please respect the sacrifice the jurors are making. So jurors are sequestered for however many weeks this takes. Well, no more, no less than 13th through the 31st, according to Judge Gull. Man, I wouldn't want to be on her bad side. Jeez. All right, so this is a motion for pretrial hearing that we got from the defense today. So here we go. So we're going to go through, as well as, I know the thumbnail says, this is, what is it? Like I said, I wanted to throw a bunch of these motions in one. So it's the defense replies to the state's response for sanctions. We will get to that and more. So just wait. All right. So we're on the pretrial motion right now. Comes now the defendant, Richard Allen, by attorneys Bradley A. Rosie and Andrew J. Baldwin, and respectfully request at this court conduct a pretrial hearing to address scheduling and other procedural matters involving the jury trial in this case. In support of said motion, defendant Allen states as follows. On March 6th, 2024, Richard Allen filed his motion for early trial. The motion did not make any references to the anticipated length of said trial. The motion satisfied the requirements of Rule whatever. Number 2, on March 7th, 2024, the court issued an order granting said request and set the matter for jury trial between the dates of May 13th and the 31st. The order was uploaded to the chronological case summary on March 11th. Number 3, between March 7th and April 25th, there were no communications from the court to the parties as to any matters associated with the procedural aspects of the jury trial. Number 4, on April 25th, 2024, Attorney Rosie reached out to court via email, so he emailed Gull, to address housekeeping matters. Said email addressed issues including, but not limited to, the logistics associated with defendant Allen's attendance at the trial and the need for a working space in or around the courthouse to store defendant's trial materials. The email also requested that the defense be offered up a location in or around the courthouse to meet with defendant in a private and confidential setting. So they want to meet with their client confidentially, which is their right. Number 5, on April 28th, 2024, the court responded via email to various requests and within said response admonished the parties that the trial schedule contains no flexibility, not more or less, as the court had not received any objections by the attorneys regarding the court's order of March 7th, 2024. See attached partially redacted email from the 28th, which contains redacted information, communication above and beyond that which is relevant to the filing. So the email that we just read. Number 6. The court further acknowledged... Did we read all that? Yeah, okay, just checking. The court further acknowledged that the court was unaware of how many witnesses the prosecution intends to call, nor on how long their case will take to present, and reaffirmed the schedule referenced above. The court also referenced that the defense claimed that it would take a couple of weeks to present its case, presumably referring to a phone conversation between the parties back in September or October of 2023 when Attorney Rosie confirmed with the court that the defense intended to try the case on the previously scheduled January of 2024 setting. So that's when he was referring to. Finally, the court acknowledged that the court was unaware of what exactly the defense intends to present, to which the defense would respond exculpatory evidence tending to show that Richard Allen is not guilty of the crimes for which he has been charged. Either way, the court's unawareness of the nature of the defense's presentation and the state's presentation would naturally be the catalyst for pretrial discussions regarding scheduling and logistics. And also, her unawareness is pretty freaking dumb because the defense has been filing in all of their motions. Hey, it's not our guy. It's probably these guys, and here's why. I have no idea what you'll be presenting because it's all inadmissible in my eyes. That's Judge Gull. That's my impression of her. All right, so number 7. Over the past several weeks, the parties have filed notices reflecting their exchanges of witness and exhibit list. The state's original witness list contained 118 witnesses and approximately 93 exhibits. The defense's original list contained approximately 71 specifically referenced witnesses, not including several others that were referenced more generally as having been associated with various motions and memorandums filed by the defense. Supplemental lists have been filed by both parties, further expanding the volume of witnesses and exhibits. While there are some duplicated witnesses, there are many that are not. In fairness, the court is unaware of the details regarding these lists as the parties have filed only notices with the court, memorializing the exchange of such lists with each other. This approach also assisted in maintaining some privacy with regard to those individuals who were going to be testifying at the trial in this cause. I think you mean the case. Number 8. Or maybe not. I don't know. All right, number 8. In addition to the raw amount of witnesses and exhibits that have been noticed up by each party, there exists logical challenges knowing defendant Allen will be transported to and from the trial significant distances each and every day, possibly as much as an hour and a half each way. Because remember, they moved him to that Wabash place, and it's even farther than the Westville Correctional Facility. It's even farther and difficult to get to, out in the middle of nowhere, not where his attorneys are. In addition, defendant Allen's attorneys will the court confirmed this. Hold on. Okay. Yeah, the court confirmed this in its email to the parties on the 29th. In addition, defendant Allen's attorneys will be traveling from communities outside of Delphi. The court's instructions seem to suggest that the jurors will also be located a distance away from Delphi. It seems natural that there will be additional challenges that cause delays in the trial, thereby consuming even more of the time allotted to the presentation of evidence. Number 9. It is also noteworthy that the court has denied summarily almost every pretrial challenge by the defense throughout this case. The net effect of these summary denials is that the defense will be required to introduce evidence by way of offers to prove and other procedural techniques in the absence of the jury, but during the course of the trial. This, of course, will cause further delays. Number 10, federal courts have a well-documented history of regulating the presentation of evidence to ensure the orderly disposition of both criminal and civil cases. This approach is much less evident in the context of state law. Any existing case law addressing the court's inherent authority to regulate the presentation of evidence typically involves family law matters, not jury trials in criminal cases. For time limits to be reasonable and not arbitrary, a trial judge needs to review the case and consider the evidence each side intends to proffer. Generally, time limits should be imposed only after the court has made an informed analysis based on a review of the parties' proposed witness lists and proffered testimony, as well as their estimates of trial time, which she has not even asked them for in recent weeks. I mean, it was like months ago she asked them something and they said, oh, a couple of weeks. Like, that's not even an accurate answer. Like, if you had your pretrial hearing, you should be able to say, I need 2-3 weeks or whatever it is. You should be able to tell her that and make sure that the correct amount of time is allotted for both sides. It's crazy that there's time limits. All right, when a court sets limits on presentation of evidence, even before the listing of proposed witnesses, it will be considered an apparently arbitrary limitation imposed in the interest of conserving judicial resources. Bam. Mic drop. Judge, you're wrong. Number 11. The primary goal in filing this motion is to ensure that the court has set aside adequate time for Defendant Allen to present a comprehensive and meaningful defense consistent with his rights under the Sixth Amendment of the United States Constitution. The defense has no control over the manner or methodology of the state's presentation of evidence, including the length of said presentation, which, under the current scheduling regimen, could consume the entirety of the May 2023 trial setting. I think he meant 24. All right, 12. When time limits are set, the court must ensure that it allocates trial time even-handedly. That does not necessarily mean each side must receive the same amount of time. In a complicated case, for example, the presentation of competent defense may require more time than presentation of a plaintiff's case in chief. And this case is complicated if it's anything. Number 13, Defendant Allen seeks equity in the amount of time offered up to present his case. As referenced above, the state could easily exhaust the entirety of the 2.5-week trial setting. Like, who said it was going to be 2.5 weeks only? I mean, she limited it, and that was that. Like, what? That, and arbitrarily, I would say. All right, so as referenced above, the state could easily exhaust the entirety of the 2.5-week trial setting, excluding jury selection. So yeah, that's not even jury selection. Thereby, jury selection starts the 13th, and it's supposed to only go till the 31st, apparently. The trial and jury selection. All right, so thereby leaving the defense with very little to no time to present its case, there would also be little time for rebuttal on either side to the extent it is necessary. Number 14, the court's approach to such a rigid trial schedule infringes upon Defendant Allen's Sixth Amendment rights and underscores the need for the court to conduct a scheduling hearing regarding the trial. Number 15, this case does not present itself to the court as a case the first impression, at least not from a scheduling standpoint. Your Honor previously presided over the case of State versus Bob Leonard in 2016. The trial consisted of approximately 34 days of testimony with nearly 140 witnesses. And so why are you limiting them for 2.5 weeks only? Because, the state has no case and you want to railroad the defense again. That's why. The defense sees similarities between the volumes of witnesses and therefore believes the case may require a similar amount of time. Number 16, to the extent any references were made back in September or October of 2023 regarding the potential length of a trial, those references would have occurred prior to this court disqualifying the defense team. The delay caused by said disqualification has resulted in the creation of additional discovery, which has in turn resulted in the need for additional time to present Defendant Allen's defense. So you have no one to blame but yourself, Judge Gull. And 17, it is for these reasons that the defense requests a pretrial hearing to discuss scheduling issues associated with the trial, secure the appropriate amount of trial time for Defendant Allen to present a full and comprehensive defense, and to address any other pretrial matters that may be necessary to ensure a just and speedy disposition of this cause. Oh, okay, he did mean cause. All right, so this was filed way early in the morning. Let me just double check and see if we do have any kind of response from the I gotta go to Reddit. All right, so Delphi Docs, that's where I go. Delphi Docs is great. So no, there's nothing recent about Judge Gull putting in any orders. So she has not responded as of yet that I am aware of. She has not responded to scheduling a motion for pretrial hearing. This was filed 8:58 a.m. This is now late in the evening that I'm recording this. So, you know, she could have responded if she wanted to. All right. So this next motion is the accused's reply to the state's response to the motion to compel and for sanctions and all that jazz. So this is, it's like the he said, she said, he said, and then she said again. It's like layer on layer. It's the accused's reply to the state's response to the motion. So, yeah, so the defense filed a motion for sanctions on Nick McClelland, and the state responded to it. I did both in separate videos on my channel, and now this is the defendant responding to the state's response to their original motion. So it's very confusing, but you get it, right? Okay, I hope so. All right, so comes now. I can make that a little bit bigger since this font is kind of hard to read. Comes now the accused, Richard Allen, by and through counsel, and files the following reply to the state's response to defendant's motion to compel and request for sanctions filed April 23rd, 2024. He ran out of air on that one. All right, so belated disclosure of Todd Click letter and evidence. Number 1. In paragraph 15 of its response, the state of Indiana pled to this court that the state of Indiana did not delay in turning over evidence from Todd Click. That assertion is false. Number 2, the defense previously provided to this court Exhibits 1 through 3, its memorandum in support of the accused's motion for Frank's hearing filed on September 18th. Exhibit 1 is a copy of the envelope containing the Todd Click letter and information, which is stamped, received May 1st, 2023, Carroll County Prosecutor. The prosecution did not disclose the letter to Mr. Allen's counsel until approximately September 8th, 2023, which is 4 months and 4 days after the prosecution's receipt. And I would say that's a big deal because this is Todd Click's letter talking about exculpatory evidence for Richard Allen, and you didn't give it over until 4.5 months later. All right, so number 3, the letter and documents sent by Todd Click clearly show that he and 2 other law enforcement officers, Greg Ferenczi of the Terre Haute Police Department and assigned to the FBI Joint Terrorism Task Force, and the officer who lost his life in the line of duty. He was basically assassinated while on the job. So unfortunately, yeah, I think he was coming out of the office building, and he was met with gunfire. So, and moving on to the document, and Kevin Murphy of the Indiana State Police believed that third-party suspects, so Greg Ferenczi, Todd Click, and this Kevin Murphy, all believed that third-party suspects were involved in the unalivings of the victims, and that the evidence against Richard Allen was not nearly as compelling as the evidence they had unearthed on certain third-party suspects. So certain third-party suspects like Brad Holder, Ron Logan, Elvis Fields, Jesse, what's his face? All these people are third-party potential suspects, the potential third-party suspects. And not only are they potentially suspects, but the police also believed that they were suspects very early on, and they were all interviewed, and those interviews have gone missing. So there's a lot of interesting things in this case. And if you don't have a bingo card with all these things, then I don't know how you can keep up, because it's really difficult. Like a scorecard or something we need for all the craziness that's happening. So number 4, because of Click's concern that the prosecution was neglecting the evidence gathered by law enforcement officers Todd Click, Greg Ferenczi, and Kevin Murphy, Click, hired a lawyer to help draft a letter to Carroll County Prosecutor Nick McClelland to alert him that he believed that third-party suspects were involved in the crimes. Number 5, it is hard to imagine a more exculpatory type of letter than one in which an investigator is courageous enough to detail that he and 2 other investigators believe the prosecution may have accused the wrong man. Click's fearlessness also involved going to the lengths of hiring a lawyer to proactively steer the prosecution towards the actual people who took the lives of Abby and Libby, and away from the possible injustice against an innocent man. I mean, wow. I mean, yeah. How do you get a better way to exculpate your client than a letter from law enforcement saying it's not him, it's these other people? And she wants us to not, like, okay, so we didn't know what was in this letter, and now he just laid out what was in the letter, and amazing. It's amazing how lawyers can, like, in these documents kind of throw out some tidbits that we didn't know that, confirm something, or it's just, it helps lay out more of what they need to get their argument on the record if the judge isn't listening to them. So you're not listening to me, I'm going to put it in my documents here saying this letter was exculpatory, and it doesn't get any better than law enforcement saying it's not this guy, it's these other people. So yeah, I mean, that's pretty powerful stuff. Number 6, additionally, through his letter, Click wanted to ensure that the prosecution had received all the evidence that Click possessed of the other third-party suspects that should be turned over to the defense. The prosecution failed to retrieve the evidence from Click until approximately August 30th, 2023. The prosecution only retrieved the evidence after it realized that the defense had learned of the third-party suspects through other documents. Say that again. The prosecution only retrieved the evidence after it realized that the defense had learned of the third-party suspects. I mean, if that doesn't say something, there is clearly a cover-up going on. We all see it, Delphi. We see it, Judge Gull, and we see how corrupt you're being. I think that she's really just trying to, like, get this guy convicted as fast as possible and not follow due process in any way so that she can just get him convicted, and then maybe it can be overturned later, possibly, but I don't know. She's totally violating all of his rights. And it's evident. And it's so frustrating as, like, for a defense attorney, it's got to be so frustrating to constantly go through these hurdles. I would hate it. I would absolutely hate being told no constantly. Prosecution failed to retrieve the evidence. Okay, I read that. All right, so number 7, the evidence that the prosecution failed to retrieve for 4 months included the following: multiple interviews of Elvis Fields, interviews of Rod Abrams, interviews of Ned Smith, interviews of Johnny Messer. That's the Jesse guy that I thought I was saying accurately. Nope, it was Johnny Messer, not Jesse. Johnny Messer is who I meant when I said Jesse. Anyways, and additional interviews. So interviews of all of these individuals who, they could be third-party suspects, and additional interviews, but we didn't get them for over 4 months. Number 8, the prosecution had never disclosed any of these documents to Mr. Allen's counsel until September 8th. Number 9, there were many exculpatory statements made by witnesses discovered in these interviews, including a key piece of evidence that connected Elvis Fields, Rod Abrams, and Ned Smith, all of whom resided in or near Rushville, to Brad Holder in the Logansport, Delphi area. So there's a connection between all of them. And we're ignoring this because why? Judge Gull? I don't know. Number 10, this key piece of evidence, as well as other evidence, was not known by the defense until the state of Indiana provided it to the defense on September 8th, 2023, nearly 9 months later than required by rule, and over 4 months after the prosecution learned of the existence of this video possessed by Click. Number 11, because of this late discovery, the defense was denied the ability to conduct its investigation in a more efficient manner and more quickly focus its defense on third-party suspects, thereby putting the defense behind where it would have been in terms of preparation than if the state had complied with the rules. So you can't get back that 4 months of investigation time, and the prosecution took that from us. That's why there are rules of turning over evidence discovery in a timely fashion. That's why. Because you can't get back those 4 months, 9 months, whatever, how many months to investigate into your client's innocence. Number 12. On April 29th, 2024, the prosecution filed a motion requesting this court to limit or deny Mr. Allen the ability to present evidence of third-party suspects to a jury. Yes, and we read that. All right, so 13, Mr. Allen's counsel believes that this further supports its contention that the prosecution was attempting to conceal evidence of third-party suspects throughout this case. So you've been trying to hide it from me this whole time, and now you don't want me to talk about it in my case. So that confirms that, yeah, there is some third-party guilt that you want nobody to look at. You want us to all look in another direction. And this includes the identity of a Purdue professor that they concealed for months, as well as the Click material detailed above. All right, so 14, Mr. Allen requests that the prosecution be sanctioned for not turning this exculpatory evidence over to the defense, and then for falsely claiming to this court that the prosecution did not delay in turning over evidence from Todd Click. So not only did they withhold it, they lied about withholding it. Straight to Judge Gull's face, they lied. All right, so an email concerning Purdue professor Jeffrey Turco. 15. In paragraph 16 of his response, the prosecutor asserts the state of Indiana did not mislead or lie to the defense in an email. This short assertion consisting of just 15 words is false. Number 16, Mr. Allen's counsel provided the prosecution's September 6th email to the court as an exhibit to the defense reply to prosecution's response to the third Frank's memorandum, which was on April 2024, in April. All right, so this reply also provided the context of why this email was false and misleading concerning the identity of the Purdue professor. Furthermore, in his September 6, 2023 email, the prosecutor failed to disclose to the defense that at that time, the prosecutor already had in its possession the Purdue report and had possession of that for over 2 weeks at the time the prosecutor sent the email. So they had the Purdue report in their possession, and it stated the things that we've already discussed, that the sticks and things, the markings on the girls were consistent with runes or with a Norse mythology type thing, whatever type, whatever the exact phrase is that they use. But that's exactly, I mean, that's what he says, that it is consistent with Norse runes. So, I mean, can't deny it. All right, so number 17, apparently the prosecution believes that with this court, it can simply make an assertion without facts, arguments, or supportive documentation, and that will be enough for the court to ignore the defense's request that the prosecutor be sanctioned for providing false and misleading information to the defense. Number 18, the defense is requesting this court to order the prosecutor to explain why he provided false information and misled the defense, and also to be sanctioned for doing so. Outstanding discovery. Number 19. The defense rejects the prosecution's assertion in paragraph 7 of its response that all information minus the SOPs and the chain of custody documents was all. Hazel? She's making tons of noise. Dog, can you lay down, please? Stop. She's trying to, like, pick up bones and play with... Oh, my God. She's going to be so annoying. Hold on. Good girl. Thank you. Okay. Sorry. Would have been really loud. She likes to, like, drag her bones and throw them on the floor when, she's loud. So, okay. So, the defense rejects the prosecution's assertion in paragraph 7 of its response that all the information minus the SOPs and the chain of custody documents was already in the possession of the defense. So that was not true. Number 20, on Friday, April 26, 2024, the prosecution turned over a multitude. So just this last Friday, just this last week, the prosecution turned over a multitude of documents, including an exculpatory piece of evidence concerning phone pings that was contained in a report written by Steve Mullins of the Delphi Police Department on August 23, 2017. I cannot believe that this case is still going forward with all of this exculpatory stuff. It's Judge Gull, because she's so corrupt. Number 21, Mr. Allen's counsel previously asked, and the prosecution, they're corrupt too. Mr. Allen's counsel previously asked multiple times for the prosecution to turn over narrative reports related to phone activity, such as geofencing and pings, and the state of Indiana has continually told the defense that no such reports exist. Are you kidding me? Number 22, the exculpatory report the defense received on this past Friday, just days ago, 17 days before trial begins, provides evidence that the victims were not at the crime scene on February 13th, 2017. What? This report that the defense just received provides evidence that the victims weren't even at the crime scene on the 13th. So there goes the state's theory. Wow. All right, number 23. The prosecution claims that it has turned over all the evidence and asserts in paragraph 5 that it has no idea why the defense cannot locate the documents, and that in order to locate the items to appease the defense, the state has to dive into 26 terabytes of information, often searching several files before documents can be found. Well, if it's taking you guys that long to find them, like, isn't that proof? Come on, guys. 24. The defense posits this question. If it is complicated and time-consuming for the prosecution to dive into 26 terabytes of information and requires searching through several files before just a few documents or pieces of evidence can be found, and this is the prosecution's evidence and their organization format that they used, then how can the prosecution expect the defense to locate the items it seeks without assistance from the prosecution? The defense did not organize the discovery. The prosecution organized the discovery during the defense's first tenure on the case, and then reorganized, formatted it for the defense's second tenure. They reorganized and reformatted it for the second time around just to confuse the defense? And they, from other filings, remember, they've been given just mounds of evidence that may or may not even pertain to this case. So what are they doing? Besides trying to either force the defense to waive their speedy trial again, or I don't know. I don't know whether they're either trying to do that or get the defense to give up the third party. I don't know. I don't know. They're not going to do that, though. All right, so 25. Richard Allen and his lawyers have only reached out to the prosecution after they had spent several hours searching for documents throughout the state of Indiana's convoluted, disorganized, and often untimely discovery dumps. Number 26, with collective experience of over 70 years, Mr. Allen's attorneys have never experienced a situation where the prosecution has created such significant barriers to locating evidence while also misleading the defense concerning the existence of evidence. So not only all this, but they are trying to mislead us just concerning the evidence portion of it, like trying to find the things, trying to make it super difficult to find. Wherefore, Richard Allen, by counsel, files his reply to the state of Indiana's response and respectfully requests the court to 1. Sanction the prosecution as previously requested in its motion to compel and motion for sanctions. 2. Sanction the prosecution for providing false information in its response. 3. As a result of said sanctions, to order the prosecution to provide an itemized list of all documents, videos, recordings, and other evidence provided to Mr. Allen's attorneys and the location of each item. Number 4, order the prosecution to explain misleading and false representations contained in its September 6th email. And 5, for all other just and proper relief in the premises. Signed, Andy Baldwin, Brad Rosie, and Jennifer Auger. Wow. I mean, just wow. Like, this is explosive. I can't even. And I can feel the anger coming off of the page from this. These attorneys have just had it with the prosecution. I can tell. I can tell by reading these. All right, so now I'm adding to this wasn't even going to be part of this video, but it came out today. So the defendants now have responded to the state's motion in limine, which is basically they just wanted to cut the defense off at the knees and make it so that they would be barred completely from a third-party defense, from providing any kind of odinist, anything, any kind of theory that they have. Basically, trying to eliminate them from doing so. So this is the defense's response to that motion that Nick just filed yesterday, or Monday, I should say. And so this motion, I don't know, it must have just been, it was just today. So today, the 30th, April 30th, I'm probably putting this video on May 3rd, or May 1st, I mean. So, just so you're clear. All right, so defendant's response to state's motion in limine and request for hearing comes now the defendant, Richard Allen, by counsel Bradley A. Rosie, and in response to the state's motion in limine file marked April 29th, 2024, defendant Allen states as follows. Number 1. On April 28, 2024, at 11:15 a.m., the court directed an email to both the state and the defense addressing various legal and logistical matters associated with the forthcoming jury trial. And what does that say? See partially redacted email. We just read through it. Okay. In the second to last paragraph of the email, the court, without any prompting by lawyers from either side, included the following statement. I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators in the charged crimes, those allegations are unsupported and will be inadmissible. Number 2. On April 29, 2024, at 12:09 a.m., the state, without hesitation, accepted the court's invitation to limit evidence regarding third-party perpetrators. Paragraph 7 in the state's motion in limine is proof of this fact. Number 3. The court has established a pattern of summarily denying pretrial evidentiary motions filed by the defense throughout this case. The motions have been denied despite the defense supporting many of its motions with evidentiary support in the form of video interviews, audio interviews, crime scene photos, affidavits of witnesses, and various other forms of corroborating documentation. In contrast, the state's motion in limine contains no supporting documents or other information justifying any limitations on the defendant's ability to present evidence regarding third-party perpetrators. And we read through it, and no, it does not provide any evidence as to why they should be permitted from talking about third-party perpetrators. Number 4. Defendant Allen's defense team is quite familiar with the law regarding the admissibility of evidence of third-party perpetrators, which requires only that defendant Allen establish some connection between the third-party perpetrator and the crime. The court must balance defendant Allen's Sixth Amendment right to present a defense with the state's desire to limit such evidence. Not just the state's desire, but the court's desire to limit the evidence as well. So you've been denying everything we put in front of your face, so please make a note of that when you are about to just get rid of Allen's right to a defense completely, which is what the motion in limine is designed to do. All right. Number 5. The defense has spent the better part of a year conducting discovery, seeking out exculpatory evidence from the state, and developing credible defense-related theories, which the defense intends to present to the jury in this case. The state of Indiana has sought out no assistance from the court in an attempt to limit the discovery process. In fact, the defense has conducted numerous depositions involving third-party perpetrators without the state seeking any orders of protection or orders limiting the discovery process. 6. The defense anticipates that its trial presentation will include somewhere between 1 to 2 dozen witnesses that will provide relevant and credible information for the jury regarding the culpability of third-party perpetrators. Blah, say that 10 times fast. Culpability of third-party perpetrators. I keep saying third-party perpetrators. It's like a one-eyed, one-horned, flying purple people eater. It's hard to say 10 times fast. All right, to the extent the court carries out its warning referenced in the April 28th email, the trial will be reduced to unnecessary delays due to lengthy offers to prove and lengthy delays due to large gaps in the scheduling of witnesses to appear for trial testimony. The absence of any articulated and reasoned legal guidance from the court in advance of the trial would promote the lack of judicial economy throughout the proceedings. Number 7, the defense requests the court set the state's motion in limine for a hearing for a full day during the week of beginning May 6th, at which time the parties would be entitled to present evidence regarding admissibility of third-party perpetrator evidence. I can't say that. Can you sit down, dog? I keep bumping my mic cord. Lay down. All right, so this approach to the business, sorry guys, and she's not done. I'm effing done with her for the moment. She's irritating me. All right, so the defense requests the court set the state's motion in limine for a hearing for a full day during the week beginning May 6th, at which time the parties would be entitled to present evidence regarding admissibility of third-party perpetrator. Oh, I said it, evidence. This approach to the business of jurisprudence would assist in clarifying the nature and scope of the evidence to be admitted at trial, which would benefit both parties, the court and the jury. Number 8, in its motion in limine, the state requested to limit evidence regarding several other matters. The defense's response to each request for limiting instructions is as follows. State's paragraph 1. Like a fuzz on my mouth or something stuck to my lip. State's paragraph 1. State requests relief from any comments about counsel for the state that constitutes a personal attack on the attorney or for the state or comments on the role of the state's attorney. Said request is unsupported by any specific facts or allegations and therefore should be denied. The attorneys, including counsel for the state, are bound by the rules of professional conduct, which constitute the person. Wait, what? Something got cut off. Which constitute. Okay, so a line got cut off. Something which constitute the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. The state provides no specific facts or documentation supporting its request for this limiting instruction. The request is unsupported and should be denied. So they're requesting personal opinion, not based on evidence to come out or something. I don't know. That's something along those lines. All right, so state's paragraph number 3. The state seeks limitations on the defense as it relates to innuendos or inferences that are not supported by admissible evidence. The request is overly broad, unsupported by factual allegations, and therefore should be denied. State's paragraph 4. The state seeks to limit the defense's ability to conduct voir dire through the introduction of substantive issues in the case to the jury pool. The state provides no specific references to what substantive issues should be limited. The request is overbroad, unsupported by any specific facts, and therefore should be denied. State's paragraph number 5. The state seeks to limit the defense's ability to question potential jurors about their feelings about the credibility of certain anticipated trial witnesses. The state's request contains no specific facts that would support such a concern. The state's request is overly broad and therefore should be denied. State's paragraph number 6. The state seeks to limit the defense from introducing hypothetical questions that include facts that are not in evidence or questions that are not helpful in violation of Rule 704. The state's request is overly broad and contains no facts or issues for which said anticipated hypothetical questions would address. Therefore, the state's request should be denied. Same thing for 7, same thing for 8, same thing for 9. The state seeks, oh no, not for 9. For 9, the state seeks to limit the defense's ability to challenge the state's geofencing expert, Kevin Horan. Based on relevance, the state's request is overly broad, contains no specific facts, which the state is seeking to limit, and usurps the defendant's Sixth Amendment right to present a defense. Therefore, the state's request should be denied. State's paragraph 10. The state seeks to limit the introduction of prior bad acts pursuant to the evidentiary values. Again, the state provides no specific facts to support its request for limiting instruction. The trial court has granted broad discretion in administering the rules of evidence in a fair and just manner during the course of the trial. The state's request is also overly broad and therefore should be denied. State's paragraph 11. The state seeks to limit evidence related to its own failure to provide the defense discovery consistent with a local rule regarding discovery and consistent with Rule 2.5 of the Indianic Rules of Criminal Procedure. However, the state provides no specific facts to support its requests for a limiting instruction. Therefore, the state's request should be denied. And states paragraph 12, the state seeks to limit the defendant's ability to offer up PowerPoint presentations that were created by the state and its investigative team over the course of the 6-year investigation in this case. The state's motion provides no documentation to support its request for a limiting instruction. Therefore, the state's request should be denied, wherefore defendant Allen respectfully requests that this court schedule an all-day hearing on the state's motion in limine as it relates to third-party perpetrator evidence. Defendant Allen believes that said hearing is necessary to ensure a fair, efficient, and just determination of the facts to be presented to the jury in this cause. Defendant Allen requests that said hearing be scheduled during the week beginning May 6th. So, that is the defendant's response to the motion in limine. Basically, they think the state's motion in limine is a bunch of hooey. There's no supporting law that they've provided or basis as to why these things should be limited. So everything that the state requested in their motion in limine should be denied. But don't take our word for it. Let's have a hearing. And you know, one of those things that you like to not have and you just deny things without. But let's have a hearing about it so that both sides can communicate, talk about their needs and what they're going to present and whatnot, all that logistical stuff. You know, let's have a conversation with them and find out how long they actually need to present their case. That might, you know, be helpful since she never did that. And, you know, a lot of little things that they could, you know, wrap up in this all-day hearing that Judge Gull just likes to throw blanket statements in emails saying, I am quite familiar with the law regarding third-party perpetrators, and unless the defense can provide a nexus between any alleged third-party perpetrators and the charged crimes, those allegations are unsupported and will be inadmissible. I like in the defense, in the defendant's motion, where does she say it, or they say it? Was it the other one? I don't know. Something about the defense is also well aware of the limitations of, or not limitations, but is well aware of third-party perpetrator requirements for a defense. Their defense attorneys, they should know how to defend their clients. They're probably going to be pretty well versed on how to bring in third-party perpetrators. So, I mean, to me, everything that I've read so far in all the Frank's memos, I'm there. I believe them. I'm on board with the defense. Conspiracy theory nut job that I am. Not really. I'm not. I look at the facts, and it's crazy as it all sounds. It has, like, there's evidence about it. There's a basis as to what these defense attorneys are saying. They can't just lie. People say, oh, defense attorneys can just lie. No, they can't. All attorneys are held to the professional rules of conduct, and that includes not lying. Both the state and the defense are not allowed to lie in court documents. That doesn't mean that it doesn't happen, like in this case, but in this case, you ask for sanctions when you catch someone in a lie. That's what you do, because you're not supposed to lie in your position of power that you've been given by the court. So, yeah, it's crazy to me that we're still going through this. Like, I feel like I'm having deja vu because Karen Reid, I felt like it's crazy that we're even making it to trial, and here we are. Day 2 of trial has already concluded, and everything that's coming out is good for the defense. So I have a feeling that that's what's going to happen here, but we're not going to know because no cameras allowed. So we won't know the outcome other than will he be convicted or not. We're not going to know the actual court proceedings, and they won't be made available to anyone. I wonder if the transcript will ever, I mean, they have to make a transcript of it, right? That they have to. I don't know. There's got to be a transcript, right? I mean, just because there's a court reporter does not automatically mean that there's going to be a transcript. Somebody has to order it and pay for the court reporter to create it. But it's yeah, I wonder. They have to create one, I would think, for the record. But I don't know. If there's any lawyers in the chat or comments, please let me know in the comments below. You guys, all of you, let me know in the comments below what you think. Please give this video a like on your way out. And I thank you so much for joining me, and I will keep you updated as more filings and more things are made available to us for this case, even though we're probably not going to see a trial, which is just a shame. All right, so I am out of here. Take care, guys. Thanks for watching. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.